A simple but very common question I hear from my clients looking to create an estate plan is, why do I need a will if I have a trust? You might be thinking the same thing. If the main reason to have a trust is to avoid probate, then why do I need to have a will as well if a will does not avoid probate? My recommendation is always yes, you should have a will even if you have a trust, for three very important reasons, which we'll be discussing today. Hi, I'm Andrew Bethel, and one note before we go further, the type of will we'll be talking about today is a pour-over will. It's exactly like a typical last will and testament. It will even say last will and testament, but where your distribution would normally be, there will instead be a pour-over provision where all your assets are designated to be part of your trust estate and distributed according to how your trust distribution is laid out. Essentially, it says all my stuff, furniture in the house, tools in the garage, pictures on the wall, all that goes to my trust over there. This brings us to the first and probably most important reason for having a will with your trust, and that is that it serves as an essential safety net. Yes, a will does not avoid probate like a trust does. However, you know it also doesn't avoid probate? Having an asset subject to probate that is not sheltered or titled in your trust. If an asset, such as real estate, is in your name as an individual and not in the trust, then your family will need to go to probate court in order to pass on that property. In that case, having a pour-over will allows your family to have the judge issue an order to distribute the property to the trust so that it can then be distributed according to the distribution plan you set out in that trust. If you don't have a will, then anything caught outside your trust requiring probate is then subject to the distribution laid out in the California Probate Code. And it's not how you have it designated in your trust. Next, the pour-over will also provides the legal backing for your successor trustee of your trust to also administer your personal items and smaller assets not titled in the trust. Your regular checking account or regular car, for example. Assets not worth enough to trigger a probate is under $166,000 here in California, but that amount's going to vary by state. You will typically also sign either a schedule or a standalone assignment of your property to your trust to ensure all your assets are in trust when you pass away. A pour-over will would essentially function in the same way. Your assets not in trust are to be distributed to your trust at your passing and thus further distributed according to the trust terms. In the overwhelming majority of circumstances, though, these two reasons I just discussed don't happen, which means your pour-over will never really gets invoked, so to speak. One reason was for a safety net for the rare instance where something goes wrong. The other is legal backing for authority that is rarely ever at issue. That is until someone lawyers up and decides to cause a problem. However, the last reason to have a will with your trust is going to be situation specific, but extremely important for those it applies to. Nomination of guardians for minor children. In your will, alongside your distribution plans and executor nominations, you will also nominate who you wish to become the guardian of your minor child or children should you pass away prior to them reaching age 18. You can also designate separate guardians for the child's caretaking and their finances, but most folks nominate someone to be the guardian over everything at that point. You cannot do this in your trust. It must be done in your will. Additionally, and this is something you may have picked up on if you've been listening carefully, this is only a nomination, not a designation. Someone becoming the guardian of a minor child is going to take more than me simply writing down that I think this person should be it. A court will need to be involved, and they will need a judge's order to authorize that guardianship. However, your written word will carry great weight should your children be in that situation. In summary, Yes, you should still have a will with your trust. It provides a safety net for assets erroneously left outside the trust and subject to probate after your passing. It gives your successor trustee of your trust authority to administer all of your assets, and it's where you can nominate who you wish to become the guardian of any minor children you may have. Thank you for watching. If you enjoyed the video, be sure to check out some of our other excellent videos here, but don't forget, hit the like button, subscribe, ring the bell, and tell us what you'd like for us to cover down in the comments below.